Hello everyone and welcome to today's webinar on disciplinary issues in the workplace. Just a quick introduction first of all. My name's Chiara Petrucci. I'm a senior associate in the Labour and Employment team in Manchester, and I'll be talking to you about the second half of this webinar. So I'll hand over to Kat now to introduce herself and get cracking.
Hi everyone, thanks Chiara. First of all, as Chiara said, welcome to today's webinar on disciplinary issues in the workplace. Thank you everyone for signing up. We've had some really positive sign-ups, so it's great to see so many of you here today on a sunny Thursday afternoon. My name's Kat Wilson. I'm an associate in the Manchester Labour and Employment team, and we're going to get started then. So before we move on properly to the webinar, I just wanted to run through a couple of housekeeping points before we get started. So throughout today's webinar, all participants will be on listen-only mode, so we can't hear you, we can't see you. However, if you wish to submit any questions, you can do so by clicking the Q&A function. So I believe that it'll be on the bottom right-hand side of your screen. So if you click on that and select all panelists from the drop-down list, you can put in any questions. Now we have got quite a few sort of slides and things to get to today, so we may not be able to go through all the questions, but we'll try our best to leave 5 minutes at the end just to answer a few. Just to let you know as well, we'll also be circulating a copy of the slides after the webinar and a link to the recording as well, which I'm sure you'll all go back and rewatch over and over. So great, let's get started then. So the aim of today's webinar is to provide some practical advice on the key issues to be aware of when taking disciplinary action that may lead to termination of employment. So we're going to look at various different areas. First of all, we're going to look at some practical hints and tips to ensure that your proceedings and dismissals will stand up to scrutiny before an employment tribunal. We're also going to look at the most common mistakes made by managers and how to avoid them. And then Chiara is going to look at some typical problems, such as employees who go off with stress or just general sickness, or those who raise grievances throughout the disciplinary process and how best to address that. And we're also going to look at an effective paper trail, why it's important and what it should look like. So before we go on to the mechanics of handling a disciplinary matter, I thought it's first worth just reminding ourselves of what an employment tribunal will expect to see if a dismissal for misconduct ends up in a tribunal. So at a very simple level, as I pop down on the slide, fair reason plus a fair process equals a fair decision, which sounds fairly straightforward, but as we all know, sometimes it's not as straightforward as it may seem. So under the Employment Rights Act 1996, there's 5 potentially fair reasons to dismiss someone, and we've noted those down on the slide. So misconduct, capability, breach of statutory duty, redundancy, and some other substantial reason. Now, for the purposes of this webinar, we're going to be looking at conduct as one of the potentially fair reasons in disciplinary processes. And we're talking about misconduct. This could cover a variety of matters. So it could be anything from an employee stealing, failing to show up for work, being late to work, telling the manager to get lost, or, potentially slightly firmer words than that. Could be complaints of bullying or just general insubordination. It can vary quite a lot, and it's not just limited to behaviour within the workplace. There could be something that occurs outside the workplace. For example, someone posting something inappropriate on social media, potentially sort of disclosing confidential information, or making some sort of detrimental comment about the company. That can be dealt with under conduct as well. And when it comes to conduct, only serious acts of misconduct, so your gross misconduct, will justify an employer summarily dismissing an employee, so dismissing them without notice. And in terms of that process, the burden of proof, unlike discrimination claims, will be on the employer to establish that the reason for the dismissal was conduct, or rather misconduct. That the onus will be on you as the employer to show that. Once that's been established, the tribunal will then consider whether the employer acted reasonably in treating the reason as a sufficient reason to dismiss the employee, and there's lots of different factors that they'll take into account when considering that. And when considering the question of reasonableness, the tribunal will consider if the decision fell within the band of reasonable responses of a reasonable employer, which is probably a phrase that you've heard before. That's the general test. So it's not therefore whether the tribunal considers the decision to be reasonable, but whether it was reasonable, bearing in mind the fact that other employers might reasonably react in different ways to the same situation. And when they're thinking about that, they'll bear in mind sort of the resources of different employers, the size of the business. All the circumstances will be taken into account when deciding what's reasonable. One thing that is crucial, though, no matter how big your business is a fair process. It's absolutely essential if you want to demonstrate a fair dismissal. So in terms of establishing a fair process, there are a few important documents to be aware of when handling disciplinary matters. So first and foremost, it's your own disciplinary policy. So it probably goes without saying that employees should usually ensure that they manage any misconduct in accordance with their own disciplinary policy so far as they're able to. Even if the policy isn't contractual, which it shouldn't be, you should still be following that policy as best as possible. That's why it's really, really important to have a clear disciplinary policy in place so that you can deal with any misconduct consistently and effectively. And whilst a failure to comply with your own policy won't necessarily be fatal, so it won't automatically be an unfair dismissal just because you've not followed your own policy, it's definitely something that the tribunal are going to take into account. So it's just worth being wary of. And if you have any concerns that your disciplinary policy isn't up to scratch, I'd recommend getting some advice on that. The other key document that you should be aware of is the statutory ACAS Code of Practice on disciplinary and grievance procedures. You've probably again all heard of this. If you've not already got a copy, I'd go and have a look, seek it out, save a copy to your desktop. Whenever you're dealing with any disciplinary, I would always recommend just having a read through the ACAS Code of Practice and just refreshing yourself. It's essentially the holy Bible when it comes to disciplinary, so it's really important to be familiar with that. And it doesn't just apply to dismissals as well, it applies to general warnings and things. So it's a really useful code of practice, and it includes some sort of basic practical guidance as well as some certain key principles that you should always be observing when you're handling a disciplinary process. So I'll just run through those key principles quickly now. I'll come on to them in further detail shortly, but generally the main points are that issues should be dealt with promptly. So there shouldn't be any unreasonable delays. That's whether starting an investigation, holding meetings, delivering an outcome. You should also always bear in mind that there shouldn't be any unreasonable delays. You need to be consistent with how you approach disciplinary matters. So if someone's accused of the same misconduct as another employee, you need to be looking at being consistent with how you look into both of them. You need to carry out an investigation, and I'll come on to that soon. You need to inform the employees of the allegations against them. That's really, really important. They need to be aware of the allegations and given as much detail as you have regarding the allegations, and they should always be offered a right to appeal. Now, sort of similar to the disciplinary process, a failure to follow the code doesn't in itself make a party liable to legal proceedings. You can't bring a claim just for failing to follow it, but the tribunal can adjust awards by up to 25% either way for any unreasonable failure by either party to follow the code. So it applies to the employees as well. So if they're being unreasonable, then the potentially the 25% uplift could apply there as well. But it's just worth bearing in mind because it is really important. And when it comes to disciplinary matters, as well as the statutory guidance, there's also the general ACAS guide. So again, it's worth taking a look at this, getting yourself familiar with it. As I say, it's not binding, but it's really, really useful. And the tribunal will also look at a huge body of case law as well when considering whether dismissal is fair or not and whether there's been similar circumstances in the past. And now I thought it's probably just worth quickly saying, oh, and I've just seen a question there. Yes, we will be sharing the recording after the webinar. So yeah, I just thought it was important just to touch upon as well. And I know the purpose of today is to look more at the disciplinary process, but not all misconduct matters have to be dealt with formally. And the ACAS code does encourage employers to look at resolving disciplinary issues informally if appropriate. So it actually says a quiet word is often all that is required to resolve an issue. I mean, obviously this will very much depend on the circumstance, and it's worth being sensible when you're considering whether or not something may be best dealt with informally. For example, if you're looking at allegations of, serious sexual harassment or anything like that, discrimination, then it's never going to be appropriate to deal with it informally. But if it's maybe general insubordination, a little bit back chat, that sort of thing, your less serious matters, or if it's more of a one-off, then it may be important, considering whether or not it needs to be going through a formal process or whether it can simply be just a bit of an informal warning in the first instance. So moving on to look at suspension then. So in certain circumstances, consideration should be given to a brief period of suspension whilst an investigation is being conducted. As I've set out on the slide, this really shouldn't be a knee-jerk reaction though, because if an employer suspends an employee in circumstances when it's not reasonably warranted, this may amount to a breach of trust and confidence and could result in them resigning and claiming constructive dismissal. So you really need to be careful when it comes to deciding whether or not it's appropriate, because it is a really useful tool when it's used correctly, but if it's not used correctly, then there can be downsides to it as well. So what should you be considering then when you're thinking about whether it's appropriate? You should also always consider whether you think their involvement is going to have, intimidate possible witnesses, for example. Is there going to be a risk of retaliation if they stay in the business? Do we think there's a risk that they could potentially obscure evidence or potentially prejudice a fair investigation? For example, I dealt with a matter not too long ago involving the head of IT, and there were some complaints raised about him submitting fraudulent expenses claims. So he was putting in thousands of pounds worth of expenses claims for monies that he'd spent downloading various software and old tech stuff for the company. A more junior member of his team raised concerns about this and flagged it with a member of HR, sent them an email saying we're not sure where this money is actually going. Didn't hear anything back. A couple of days later, they saw the HR person, gave them a ring, and they hadn't received the email. And when they then went on and looked at the system, the head of IT had deleted the email that had been sent raising the concerns. They'd also started deleting other documents. Now, in circumstances like that, it's probably going to be appropriate to suspend them because you don't want them having access to some of those, documents and potentially prejudicing the situation. But in other circumstances, it might not be necessary, and it's always worth bearing in mind the seniority of the individual, any access to confidential information, any sort of concerns about intimidation of witnesses, if there's been allegations of bullying raised against a senior manager by people in their team, would it be appropriate for them to still be within the team whilst it's being investigated? Which brings me on to my next point, that you should also be considering any alternatives that would achieve the same aims of removing them from the business or removing them from a specific team. So, for example, could it be achieved by just moving them to a different location temporarily? Could you just remove access to certain documents on the system? If there's other ways of achieving what you're trying to achieve from the suspension, then it's worth bearing them in mind as well. Just a few other points I thought it's worth mentioning on the suspension point, more of a sort of procedural points to consider. So you should always be informing the employee of the reason for the suspension. It's not enough to simply state misconduct. Any suspension should be confirmed in writing as soon as possible as well, ideally on the day of suspension, but you really need to be putting in actual details of the allegations. I've seen it often where it's just quite a vague reference to, poor behaviour and things like that. You need to be as specific as possible when setting it out in the letter, and as I say, delivering it to them as soon as possible. What's it really important to have in there as well is just a point that says the suspension does not mean that you formed any view about whether or not they've committed the wrongdoing. It's always important to have that in the letter just to make it clear that, it's not a foregone conclusion, but you're just doing this so that you can investigate it properly. You need to inform them of the terms of the suspension. So, for example, do they still need to be contactable by telephone in the working day? Remind them not to contact any colleagues, customers, employees, suppliers, anything like that they need to be made aware of. They should also be kept on suspension on pay. Unless there's really exceptional circumstances, it should always be a paid suspension. And I would strongly recommend that if you're considering putting them on an unpaid suspension, that you take advice before doing that. And finally, you need to make sure you're keeping the suspension under review. I've seen it in the past where people have been suspended for, 6, 7, 8, 9 months even. And that's really not what the suspension is there for. It's not for when you don't know what to do with someone. So we're going to suspend them because, we don't really know how to handle this. It needs to be reviewed, and you need to be getting in touch with them and justifying the suspension if it's carrying on for a long period of time. Maybe after an investigation's taking place before a disciplinary hearing, maybe you can write to them and just update them and say you'll be staying on suspension because of XYZ reasons. Just make sure that you're keeping them informed. So moving on to the investigation, so you've become aware of the allegations, you've made a decision whether or not you think it's appropriate to suspend, and then we're looking at the investigation. So as set out on the slides, an investigation is a really key part of a fair disciplinary procedure, and an inadequate or unfair investigation can render any subsequent dismissal unfair. So it's really, really important that you carry out a reasonable investigation. And as the ACAS code says, it needs to be a reasonable investigation to establish the facts of the case. And it's just worthwhile for you guys as well to gather the evidence and also assess the strength of the evidence as well. It's likely, depending on the size of the organisation, that you might not know anything about this individual or the allegations in much detail. So it's worth carrying out that investigation thoroughly for your own benefit as well. And then in some cases, this may mean holding an investigatory meeting with the employee before a disciplinary hearing itself, or sometimes you might decide that you don't want to speak to the employee who's accused of misconduct during the actual investigation process and just focus on gathering the information from the witnesses instead. Now, if you do that, it's not a case that you can just ambush them at the disciplinary hearing. When you write to them with the disciplinary invite, you still need to be setting out the allegations. But if you're dealing with something that's fairly straightforward and clear cut, so for example, if it's behaviour that might be uncontested, so they might have admitted to the conduct, then you might not think that it's worth having an investigation meeting with them before the disciplinary hearing. If, for example, someone's been accused of punching someone in the face and you've got CCTV evidence and 10 witnesses, again, you might not think that it's worth having an investigation meeting with the actual employee before the disciplinary hearing. But it'll just be done on a case-by-case basis, and what's reasonable will depend on the issues and the amount of facts that remain contested. Personally, I'm always of the view that it's quite helpful to speak to them during the investigation process, unless it really is very clear cut. So yeah, it's just something to bear in mind. And then in terms of the actual investigation itself, it's important to remember that the purpose is not to establish beyond reasonable doubt whether an employee has committed the alleged misconduct. You know, this isn't a criminal trial, we're not in the Crown Court, it's not, you know, beyond reasonable doubt. It's just got to be on the balance of probabilities. So if you have reasonable grounds for the employee's belief on a balance of probabilities that there has been misconduct. So it's all about that balance of probabilities. Just a few other points to remember as well. So where practicable, different people should conduct the investigation and disciplinary hearings. If it can be someone located in a different office or workspace, then that's even better. But just generally, it should be someone, if possible, who's impartial, no previous involvement, and someone who's entirely separate. And the code does recommend that as well. The ACAS code explicitly states that. So if you weren't to do that, then you're potentially looking at it being unfair and risking that 25% uplift as well. So it's just really important to remember that. Strictly speaking, employees don't actually have a right to be represented at investigation meeting, but it may be that you allow this. Check your policy, see what it says. If you do allow it, then ideally you want to just have it either a trade union rep or a colleague, unless there's certain circumstances. So for example, if they're disabled, it may be as a reasonable adjustment you allow them to bring a family member instead, or someone who's particularly vulnerable, for example. But I'd always check the policy in the first instance. And it's important to remember that ultimately no two cases are the same. So how you approach an investigation is likely to be determined by the complexity, the sensitivity of the allegations, the nature of the allegations, the amount of resources you have available as well. It's all going to depend on those, so it's just worth bearing in mind. Is it reasonable on the balance of probabilities? It's always coming back to that question when you're making any decisions regarding the investigation. And there's resources out there that can help. You can seek advice from us, or there's also the ACAS guide on conducting workplace investigations, which is really helpful. That contains some useful practical advice. So again, if you're not familiar with that, I'd recommend that you go and give it a read, download it. If there's any disciplinary investigations coming up, just refresh your memory on it. And then just very quickly on the last point of the investigation, I just wanted to briefly touch upon confidentiality. So as I'm sure you can appreciate, maintaining confidentiality is really crucial to an investigation, but I think it's just important that you don't promise it to anyone, because at the end of the day, you cannot control what people do. And you should always be reminding anyone who you take in, investigation meetings, any witnesses, you should be reminding them to keep it confidential, and you should be reminding people that if they don't, then this could potentially fall within a disciplinary procedure of itself. But I just wouldn't be making any promises of things being kept confidential, because I don't think you can do that, because you can't control what people are going to do outside the investigation. So moving on to the disciplinary investigation letter. So you've carried out the investigation, there's enough evidence there to proceed and move forward. So as set out on the slide, the letter inviting an employee to a disciplinary hearing is a really key piece of correspondence. It's therefore really important that it's drafted correctly, and it's probably one of the first things the tribunal is going to look at in a unfair dismissal claim. They're going to go in the bundle, they're going to look at that disciplinary invite letter and see what the allegations are, and that's going to be at the forefront of the mind when they're determining whether something is fair or not. So it's really important that you get it right. And there's a few things that need to be included in there to make sure that it complies with the ACAS code. And I've set these out on the slide and I'll run through them quickly now as well. So there needs to be sufficient information about the alleged misconduct and its possible consequences to enable the employee to prepare to answer the case at the disciplinary hearing. So in other words, you need to be making sure that you're spelling out the allegations in as much detail as possible. And this is one area where I often see employers fall down, where they've not been very clear about the allegations. Again, they're just sort of general statements of poor behaviour or, insubordination, but we really need to be very specific. And I always think it's worth thinking, if this was me and you were potentially accused of misconduct, potentially wrongly, what information would you want to be available for you to be able to properly defend yourself? And that's what I think it's always worth thinking in the back of your mind. And it's also really key that the accusations are consistent. I've seen it before now where the accusations seem to change from letter to letter. If you're changing the allegations in the scope, and that's likely to be unfair. So, it's best to try and avoid doing that as much as possible. In terms of evidence, so you should be providing the employees with copies of all written evidence. Anything that you're going to rely on in the disciplinary hearing, they should have seen. That includes any witness meeting notes and things as well. You should generally, unless there's very exceptional circumstances, maybe, for example, someone's raised really extreme, sexual harassment concerns and is scared about the repercussions, maybe then you could potentially consider whether it would be appropriate to withhold them. But if you think about it from a sort of point of view of the person being accused of the behaviour, if they don't know who's made the allegation and they don't know what they've said in their allegation, then it's not really very fair for them to be able to defend themselves properly. So again, just make sure they've got all the evidence and double check with them if there's any evidence as well, any sort of mitigating documents that they want to send over for you to look at. It's also advisable to inquire as to whether they have any disability or any special requirements so that you can make reasonable adjustments. We're really fortunate now that there's so many different formats that you can conduct hearings on, whether that be in person, on Teams. You can even do it, over letter and correspondence if absolutely necessary, if they're really unwell. But it's just worth finding that out at the outset. Tell them the time and the venue for the hearing. That's always useful for them to know. And also you should be informing them of the right to be accompanied at the meeting as well. So strictly, the statutory right to be accompanied is only triggered when the employer makes a request, but the ACAS code does say that you should be proactively advising them, so please make sure that you include that in any invitation letter as well. Then moving on to the actual hearing itself then. So when it comes to the disciplinary hearing, there's no definitive guide as to how it should be conducted. This will just depend very much on the nature of the allegations, what your disciplinary policy says, how many allegations are out to look at, what the evidence looks like. So yeah, it's just, there's nothing, as I say, set in stone, but it's just being sensible and making sure that you've got an adequate amount of time to cover all the allegations as well. I've seen people list disciplinary hearings for 30 minutes when there's, 5 or 6 allegations. It's probably not going to be enough time. So just be sensible with that. In terms of who's conducting the hearing, if the disciplinary policy sets out who should be conducting it, then you should follow that. But generally speaking, it should be someone who's completely impartial, doesn't ideally have any knowledge of the investigation. If it's a smaller organisation, that might be slightly more difficult, but generally speaking, it should try and be someone who's as impartial as possible, and someone who's sufficiently senior, ideally more senior than the person being accused. But I wouldn't recommend that you choose your most senior person, because you generally want to save them for any appeal. Just so someone just of who's a certain level above the individual, if that's possible. Now, in terms of asking any questions at the hearing and witnesses, we get asked this quite a lot. So the ACAS code does actually state that employees should be given a reasonable opportunity to ask questions, present evidence, and call relevant witnesses. Now, as a general rule, I wouldn't be offering the opportunity to call witnesses and, for them to ask questions of witnesses. But if this is something that they explicitly request and you speak to the witnesses and they're happy to attend, then it's probably not something that you should be unreasonably preventing them from doing, because it's all going to fall back into that question of, was it a fair process? And if they've said they want to speak to these people, and particularly if we're dealing with a situation where it's very much a he said, she said, and there's lots of conflicting statements made by people, if they've asked to speak to those witnesses, the witnesses have said they're happy to attend, then I'd recommend facilitating that as far as possible. I mean, generally, they might just give you a list of witnesses who they want you to take evidence from as part of the investigation. Don't necessarily ask for them to attend the hearing itself, but it's just worth bearing in mind, because we do every now and again get asked this about whether or not they should be allowed to bring evidence or ask questions of any evidence of any witnesses. Now, in terms of the conduct of the hearing itself, so the person carrying out the hearing, ask questions, as many questions as you like. You can use open questions, more probing questions if necessary. It's you who's leading the hearing, and you want to make sure that you get all the information that you need to make sure that you're asking the right questions. And if the employee or the rep even raises any issues that require further investigation, then you should be adjourning the hearing to go and look into those and to investigate them further. But as I said earlier, this isn't a Crown Court. You're not a judge. You're not expected to know everything there and then. So if you need to go away and look into something more, then feel free to adjourn and do that. In terms of statutory right to be accompanied, I know I touched upon this slightly in the previous slide as well, but just a reminder that they have a statutory right to be accompanied at the disciplinary or grievance hearing. And I'd remind them of that at the outset of any hearing. And if they've come without someone with them, just double check that they're happy to proceed on that basis, just to cover your back and make sure that you've covered it all off. Then in terms of making the decision, so the ACAS code makes it clear that any decision should be taken after the hearing. So you shouldn't be delivering it there and then at the actual hearing itself. It's always better that you go away, sleep on it. It also makes it look less predetermined if you're going away and having a proper think about the situation before delivering the outcome. And as touched upon, if you need to carry out any further investigations, then you should be doing that, and you can adjourn the hearing. As long as you're doing it within a reasonable time frame, that should be absolutely fine. And just make sure that you're keeping the employee informed if you're doing that, so that they're not sat around waiting for the outcome. And where there's any facts in dispute, it's going to be up to the manager to decide which version they think is most probable. And if there's new facts that emerge, then again, consider whether you need to go and investigate that so you can answer that question. But the employee should always be told roughly when they're likely to receive the outcome. Then just a very final point on notes, just to say you should always take a thorough note of the hearing. It doesn't need to be verbatim. You're not expected to do a transcript or anything like that, but take a good note. We wouldn't recommend that you try and agree that note with an employee. I know people sometimes do, but you very often just end up in a back and forth and arguing about different words and things like that. It can just waste a lot of time. So unless they're explicitly asking for it, I wouldn't opt to share the notes and try and agree them in advance. Finally then, I'll just run through the decision and then I'll hand over to Chiara. So there's two main things that you need to think about, two main components to a decision. So first of all, did they commit the conduct, the misconduct? And if so, what should the sanction be? What's the appropriate sanction? Now, as we've already mentioned, it's probably worth stressing again, an employer doesn't have to prove beyond reasonable doubt that an employee has committed the act of misconduct. That's not the threshold that you're trying to meet. The test is whether on the balance of probabilities the employer believes that the alleged act of misconduct took place. So in other words, are you satisfied that more likely than not the employee did commit the offences? And it's not for the tribunal to decide whether or not they committed the misconduct either. If it ends up in a tribunal for a claim for unfair dismissal, they're more looking at the process and whether it was reasonable, not whether he actually or she actually committed the misconduct that they're accused of. And in terms of where an employee's been accused of, a number of different acts of misconduct, it's really important that you carefully consider each one and deal with each allegation separately and do a separate finding in relation to each allegation and deal with those as separate points. And that includes when you're thinking about the sanction as well, you should deal with it on a sort of allegation by allegation basis. And when you're considering the type of penalty to impose, you should take into account a number of factors. So the seriousness of the offence, of course, and the risk of likely reoccurrence. Do we think it's likely to happen again? The background to the offence. So have there been any previous incidents that they've been involved in that are similar? Have there been any previous warnings? Are there any guidelines in the disciplinary policy or in the contract that states that certain acts would fall within, a certain area? Also, have there been any penalties imposed in similar cases in the past? So it's really important that you act consistently. So if you've dealt with something in the past that's similar circumstances, similar allegations, you've made the same sorts of findings, what was the sanction that you imposed on them? Because if you get to an employment tribunal and there's someone in the woodwork that it turns out did the exact same thing but wasn't dismissed, whereas this employee was, that could be really fatal to your case. So it's really, really important that you consider consistency. Also think about the employee's disciplinary record, length of service, any mitigating factors as well. So generally when you think misconduct, you think automatic dismissal, which is generally the case, but it's always worth just considering as well, does it necessarily justify instant dismissal or are there some mitigating factors? So length of service, for example, a clean disciplinary record, was there any provocation? Are there things going on at home? Is there anything outside of the workplace that could be affecting it that's made them act, different than they normally would? Is it quite out of character? It's worth bearing them in mind. And even if it doesn't change the outcome, at least then you can, show that you've thought about potential alternatives. And again, it's always really useful as a disciplinary officer to keep a written record of any deliberations, any considerations as you're going through the evidence, keep a note ongoing of what you're thinking in your head, because it's really useful if you end up in a tribunal 2 years down the line, because you probably won't remember exactly what happened or what your thought process was at the time. So it's really helpful just to have that there. And yeah, I think that's everything from me. I'm going to hand over to my colleague Chiara now then. Thank you for listening, everyone.
Great, thanks, Kat. And just before I crack on to the next slide, I just want to acknowledge all the great questions that are coming in. It's almost as if some of you have got a bit of a crystal ball over there. I think I'm probably going to cover some of the questions in the next few slides. If I don't, I'll try and shoehorn things in, but hopefully we might get a chance for answering some of the more discrete ones towards the end. And if we don't, we might think about doing a short blog because we've got some really good questions. So thank you for those. So just coming back to the slides. So the disciplinary outcome letter, probably one of the most important documents if you do end up going on to dismiss, along with the disciplinary hearing note. So if you're in the unfortunate position of finding yourself with a tribunal claim, this is one of the documents that both us as lawyers and the tribunal are going to be having a good look at. So an employee should be informed in writing of any decision as soon as possible after the hearing. The ACAS code doesn't give any guidance on what that means, but you should try to ensure you're at least complying with your own policies and procedures, and assuming that you do that, you're unlikely to be criticised, assuming that your time frame isn't unreasonable. So what should the letter include? So hopefully goes without saying that it should include the reason for the dismissal, and it's just kind of a reminder here to use quite clear language and be specific. There can be a temptation to use kind of legalistic phrases, but it's better to try and avoid those. One of the ones that we see a lot in theft cases is misappropriation of company stock. But if it's theft, we can just call it theft. Helpful phrases to kind of include in your letter when you're including the rationale for your findings. Things like, on balance, having considered all the evidence, I'm satisfied that, I have a reasonable belief that, and even I prefer X's evidence to Y's. We often see where something is one person's word against another, maybe saying, oh, this allegation we couldn't come to a conclusion on because it's one person's word against another. And, that might be the case, but the manager could say, I preferred Kat's evidence to Kiara's because Kat was just more credible. She was able to give detailed explanations. When I challenged her, she was able to provide reasonable responses. That is, absolutely fine to conclude that. The letter should confirm the employee's termination date and whether they're being terminated with or without notice. And if notice is being given, the letter should make it clear whether the employee is required to work out their notice period or whether they might be placed on garden leave, which is sometimes appropriate for more senior individuals. If the employee is being dismissed with immediate effect, the letter should say whether they get a pile-on or whether they aren't getting any notice because it's gross misconduct. And you should also mention a right of appeal. And then in cases that aren't dismissal, written warnings, it's really important still to set out the nature of the misconduct and any change in behaviour that you expect. And really key is the length of time that the warning is going to remain live. So normally a final written warning is on for around 12 months. So the common pitfalls with disciplinary outcome letters: failing to detail the reason for the disciplinary outcome and the evidence relied upon. So often we see that the allegations are substantiated and the decision is dismissal for gross misconduct, but it's really important to just get a level of detail in there. So this was the evidence, i.e. witness statements from various witnesses, and the reason that those witnesses' evidence is preferred to the employees in question is because all of their evidence was consistent with one another and consistent with the customer who complained or whatever it is, and the employee in question, we didn't think they were telling the truth about that, and therefore we found that the allegations are substantiated. Just helpful to kind of set all of that out. 2 is not making an employee aware that a previous warning was taken into account. Normally that's for the case of sort of top-up dismissals where someone might be on a final written warning and they've done something that maybe ordinarily wouldn't have resulted in dismissal, but because there was a final written warning, you're taking that into account. 3, I think this is one that is missed out quite commonly, which is failing to confirm whether an alternative sanction is being considered and what mitigating factors are taken into account. And I don't think this is missed out because managers don't necessarily think about it, but I think it just tends not to find its way into the letter for some reason. But I think it's really important, even if it's obvious that that the manager's probably going to dismiss, to say, well, we considered whether a final written warning would have been appropriate, but actually the employee showed no remorse. They didn't appreciate the seriousness of the allegations and the conduct, and therefore it's not believed that a final written warning would have had enough corrective action. So we felt the only option was to dismiss, or for example, if it's a health and safety issue and it's an organization that takes a really serious zero tolerance approach to health and safety issues, kind of saying that a final written warning wouldn't have been appropriate because it's so serious. It's just important to give that nod to other sanctions that have been considered. And again, what mitigating factors did you take into account? So even if someone raises that they were having personal issues at home that maybe clouded their judgment, if that isn't enough to make you step back from dismissal, that's fine, but it's just helpful to mention that you have considered it, but the conduct is so serious that that is not enough to mitigate. For not advising of a right of appeal, I think that's slightly less common. Hopefully that's in all of your templates. Not clearly specifying the termination date. This does happen sometimes where you've, say, delivered the outcome itself in a hearing, and then you're following up, say, 5 days later in writing, and you say that dismissal is with immediate effect, but you don't necessarily mention that it's with immediate effect from 5 days ago when you had the hearing. And you can run into issues, say, where a bonus became payable in the middle of those 5 days. So it's really important just to be clear on the termination date. And then 6 is failing. This is where it's not a dismissal, it's a warning. Failing to advise of the steps to rectify the issue. And the second part of this, the potential outcome if further cases of misconduct are identified. So I always think it's really important, even though you think the clue's in the name, final written warning, I always think it's really important to say within that final written warning that if there is further misconduct within the period of the warning, then one potential outcome could be that the employee is dismissed. So just moving on to the appeal hearing, which I'm going to go through quite quickly because I think the next few slides answer some of your questions that have been coming through. So I want to spend a bit more time on those. So your appeal hearing is an important element, largely because it's your opportunity to correct anything that was kind of missed at disciplinary. So if there was a part of the process that wasn't quite right, that's your opportunity to get it right again. So it's like a second bite of the cherry for employers. And also the ACAS code says that employees have a right to appeal. So you should deal with appeals as kind of quickly as you can. They should be dealt with impartially and wherever possible by a manager who hasn't previously been involved in the case. And often that should ideally be someone who's more senior than the original decision maker. And I saw a question about somewhere, sorry, there's quite a lot now, so I'm just trying to find it. There was one question about in smaller organizations, who's kind of conducting these things. And sometimes, yeah, you do have difficulty when you get to appeal stage and you haven't held someone back and you don't have someone more senior, and that is where you might start thinking about using external consultants. And the drawback of that is they're not internal, it's someone external, and you are bound by their decision. So you just have to be really kind of clear that whatever they decide, you're bound by it. And I think, again, it's just to mention that there is a statutory right to be accompanied at an appeal hearing. I'm going to move on, though, to the next slide, which I think probably lots of us have experienced, which is the employee who goes off with stress the second that they get invited to a disciplinary hearing or a disciplinary investigation. And so it can get quite tricky from here. So often employees go off with stress or depression or anxiety or other mental health issues. And whilst the skeptics amongst us might think that that's just a stalling tactic, and potentially it is in some scenarios, in other scenarios it could be very genuine. And so you kind of have to tread quite carefully. So just going to go through a few things that are helpful to consider when something like this happens. That's not to say that you have to do all of these things every single time, but it is helpful to at least consider them every single time. So the first thing to think about is whether to postpone the hearing. So if you simply push on with a disciplinary hearing despite an employee saying they're too unwell to attend, there is at least the risk that you could find that a later dismissal is unfair. And this is especially bearing in mind that the ACAS code talks about when it is appropriate to make decisions in the employee's absence. And I have seen a question on that as well. So hopefully we're going to cover that now too. So that's not to say that you will always have to wait indefinitely until the employee fully recovers. But you might want to give them a few days, or even in other cases until the end of their current fit note if they've submitted one. That doesn't then mean that when the next fit note comes in, you absolutely have to wait until the end of that fit note. It's just that you need to be considering what is appropriate. So say you've very patiently waited until the end of a 1 week fit note, and you get another fit note that comes in and it's for 4 weeks this time. At that point, I think probably the next step would be thinking about obtaining a medical report of some sort. And it often, when people go off with stress, it's the fact that they have the disciplinary overhanging that is contributing to that absence. So I think in that scenario, if the employee's unwilling or unable to indicate when they're going to be in a position to attend a disciplinary, that's a good time to think about whether you should go to occupational health or ask for a GP report, because just because someone is declared unfit, which is what it'll say on the fit note, unfit to work, it doesn't mean that they're unfit to attend a disciplinary or an investigation. And what is actually helpful is that the DWP has issued some guidance on this to GPs and occupational health professionals in its Health and Work Handbook, and it is from 2005 and hasn't been updated, but it's still just something helpful to point to. And it says it's likely that the effects of an unresolved dispute on employees' mental health may be greater if the proceedings are postponed. An employee may be unfit for work, but fit to engage with the management process. The doctor or nurse will have to assess whether attendance is likely to cause serious deterioration in the employee's mental or physical health. For example, if there is a significant risk of suicide. So that's like setting quite a high bar there, if there's a risk of suicide. And I'm not saying those are the only cases where you kind of won't be able to proceed. But it's certainly useful to point to. And I know occupational health are in some cases a lot sort of just kind of really risk averse, or can be not very helpful sometimes, and some providers are definitely better than others, but this is certainly something that's really useful to point to when you're trying to kind of push on with that disciplinary. And then finally, consider making some adjustments to enable the employee to attend. So if you're going to be thinking about moving ahead, you might offer to deal with the matter over 2 half days rather than a full day, offering additional breaks, offering to conduct it locally to the employee rather than having them come into the office, or nowadays we've got Teams, or you can give them time to prepare comments in advance. I think the really important thing is that you're acting reasonably when dealing with employees who say they're too unwell to attend a hearing. And once you've considered all of those points that we've mentioned, if you do decide to go ahead and hold the meeting in the employee's absence, it's really important that you kind of at least give them an opportunity to put forward their case in a different way. So, for example, you might submit some questions to them that they get the opportunity to answer, or just generally to put forward some written representations, and making really clear about the consequences of their failure to attend, and warning that a decision might be made in their absence if they don't attend. So hopefully that answers a couple of the questions there. I should just say, if you do go ahead and hold a hearing in an employee's absence, what you need to be careful of is to almost rehearse what they might say. So if you think they would put forward points in mitigation or things in defence, you should think about what those might be and what you would decide about those. So not just thinking about points that go against the employee, but things that they might put forward in their defence as well. And my final point on this slide is just that particular care should be given to any employees who go off, who might be considered disabled under the Equality Act, because not only could failure to make some adjustments go to whether the dismissal is fair, but also you're then into the realms of disability discrimination, which is a whole other webinar, but just a bit of a nod to that. So next slide is allegations of bias. I think we have had a question on that about whether a manager, let me find it, whether a manager can hold, can a manager who witnessed the conduct, oh no, it's not that one. Basically, can an employee's manager conduct the disciplinary or the investigation? And they can, but obviously this is kind of a nice introduction to this slide, because if there are allegations of bias, then we need to think about those. So whilst an employee is not entitled to pick and choose the person handling their disciplinary or their appeal, if they do raise a genuine and reasonable concern about a person's independence, it's usually advisable to consider whether someone else should be appointed. And obviously the choice of manager will depend on your availability within your organisation. And again, we've got a few questions on this as well, you know, about smaller organisations, and obviously you want to hold someone back for the appeal. So I think in smaller businesses, you'll probably want to be being quite robust about whether those allegations of bias, you know, are kind of reasonable. I think in larger organizations where it's a lot easier, you've probably got lots of different managers who could deal with things. If there's an allegation of bias, sometimes it might just be easier to change the person to avoid that even being an argument. In smaller organizations, it's going to be a bit harder, and you know, you'll probably want to look into whether there's anything in that allegation of bias before using someone that's then going to prevent you being able to use them at appeal. So then you might have to go external for the appeal. The next difficult area is overlapping disciplinary and grievance issues. So again, I think lots of us will have experienced this, where someone gets invited to a disciplinary and then all of a sudden they would like to raise a grievance about everything that's ever happened to them in their employment since 2003, and it's all coming to a head now, having never raised a complaint about it before. So we've all had one of those, and fortunately, the ACAS code does make it clear that where there are overlapping disciplinary and grievance cases, it might be appropriate to deal with both of those issues concurrently. Now, obviously, we all get kind of weird and wonderful grievances. So like it says there, no two cases are going to be identical. But what we've tried to do is group these types of grievances that seem to arise in response to a disciplinary into three main categories as to whether you can kind of carry on with your disciplinary or pause it. So the first one is if the grievance is totally unrelated to the disciplinary issues being addressed, it's normally safe to progress with the disciplinary. Obviously, you need to address the grievance and be seen to be doing that and actually be doing that, but that doesn't mean you have to pause the disciplinary. And that's because if it is genuinely totally unrelated, then one shouldn't have a bearing on the other. So really, we don't want that to be used as a delaying tactic for the employee. The second category is if the grievance is effectively the employee's defence to the misconduct. Again, it's normally sensible to deal with them at the same time. You know, sometimes someone is invited to a disciplinary and they raise a grievance saying, oh, it's not fair that I was invited to a disciplinary. And actually, that's just something that they need to say in their disciplinary hearing, and then that can be considered. So normally that won't warrant pausing the disciplinary. But the third category, and again, this kind of comes on to the bias questions that we've had, if the grievance seeks to basically challenge the integrity of the manager making the disciplinary decision. So, for example, my manager's always had it in for me, they shouldn't be the one to make the decision, they've been bullying me, they want me out. usually the safest course of action in that case is going to be to adjourn the process and investigate the grievance first, because any decision that that manager makes is always going to be overshadowed by the fact that they were accused of all of these things before having made that decision. And then finally, before we try, we've got 5 minutes before I try to tackle some of these questions. Got loads of really good questions coming in. Thank you for those. We will follow up because we've had some really great questions. So what can you do to help your managers? So ensure they've read your policies and procedures. It sounds really obvious, but we do get managers saying, "Oh, I've never seen that document before," when it appears in a tribunal bundle and it's the disciplinary policy under which they dismiss someone. So really useful, like Kat said, just get those in front of your managers and make sure they're familiar with the ACAS code as well. Give them training. Use your template letters, which I'm sure lots of you have. But the second part of that third bullet point is really key for me. Ensure they still address their minds to the issues and that they really own the decision. So as kind of legal and HR, we're all there for support and guidance. And as heavy as that hand-holding can get at sometimes, we really need to be clear with managers that this is their decision and it is them. If the matter was to go to a tribunal, they are the ones that need to stand behind that decision and they need to be able to explain it. And if when they are challenged, why did you make that decision to dismiss? And they say, "Oh, well, HR told me to," it's really just not going to look good. They really need to feel like it was their decision and they made it and they applied their minds to everything. So when you're kind of doing letters and providing templates, really useful to have those templates and even to kind of help with first drafts. But managers really need to make sure they are absolutely behind those letters and they've inputted into it and they agree with everything that's been said and it's all in their own words. And then also just a reminder about the importance of record keeping and a paper trail so that you can evidence steps you've taken should the matter end up in tribunal. And I know it sounds obvious, but this is something that can be overlooked. It's really annoying when you've got a really sound decision and just don't have the paperwork to back that up and you have to settle something because your paper trail's terrible. So yeah, it's just I'm sure a lot of you do make sure that you've got good records. It's also just worth bearing in mind that the documents that you are creating will be disclosable in litigation or in a DSAR or both. So just make sure that you're not putting anything in there that suggests predetermination or a lack of impartiality. And if you're kind of concerned about in more contentious cases or more high value cases about document drafting in different versions, often those are disclosable, but if you kind of draft them via a lawyer, you can preserve them via legal privilege. So that kind of brings our webinar to a close, but we've got a couple of minutes, so I might just try and what if the employee goes off sick during the investigation? We've covered it. Can you, oh, someone's asked what the DWP document was called. We are going to circulate the slides, just to let you know. So, oh, it's actually not on the slides. It's called the Health and Work Handbook. It's for GPs and occupational health professionals, and it is from 2005, but it hasn't been updated, and you should still be able to find it. Maybe we could put a link to it in a blog, because I think there's so many good questions here that it's a shame that we won't have time to do all of them. Yeah, a few people have asked for the name of that document. So I think given we've only got a minute left and there's loads of really good questions here, I think what we will do is we'll do a blog covering off some of these questions because a few of you have asked similar questions, but I'm sorry we haven't had time to cover all of those. I think I did manage to cover a few of them in the slides. So I think we will just wrap it up there and say thank you very much for joining us. Thanks for being so engaged and asking so many questions. And we will follow up. Like we said at the start, the session will be circulated and the recording link will be sent after the webinar. So keep an eye out for that. Thanks very much, everyone.
Thanks, everyone. Thanks.
Bye.